Good evening to everyone. So welcome once again to the revision that I promise we are going to be doing until the very midnight to the day of the examination, which all of you are positively looking forward to. So tonight, I want to do something a bit different. What I want to do is to have a very visible room so that I'm able to speak to a lot of things. This is what I'm going to do. I'm going to use some of the old questions so that the the question which come, they provide the point of discussion for us, and then we speak around. We are not just interested in answering the question, but we are interested having a very informed discussions around some of the areas that they have before. And that means that almost all the subject areas, insofar as they are represented in that particular year that we are engaging at the moment, we have the opportunity to speak around, raise issues, discuss, and clarify any uncertainties or ambiguities which may be lurking in your mind. So without wasting time, we what we do is that we take 2012 questions. And as I said, the idea is not just the questions and answers, but to provide a framework for extended discussion around it. Since every question itself is a pointer to a subtopic area. So, for example, I have a question that the Supreme Court Ordinance 1876, section 14, confined and received English law to that existing on. Certainly, if you have a question like this, it is a question which requires that you either know it or you do not know it. However, as I keep suggesting, in sometimes where you do not have the answer, right? You don't have certainty regarding what the right answer is. You can do some intelligent guessing around the correct answer. And that is the essence of what we call the elimination method for doing MCQ. So, of course, this is the Supreme Court Ordinance is a very foundational piece of information every student of Ghana legal system legal method must know, because as you know, talking about our Supreme Court as we have and also the modern court system, history goes back to this particular legislation, and that is, and if you look at any of the standard works of the Ghana legal system, Professor Kwanzaa of blessed memory, if we look at his work, he actually makes reference with. We also look at the more recent work. We also make a reference with. So it is important that certain basic information we know about it. So in terms of sources of law applicable to the courts, the Supreme Court ordinance made the prescription of what laws are available to the courts when they are adjudicating like the cases. So if you look at section 14 of the Supreme Court Ordinance, for example, I have the provision, and I quote, if I'm to project it, it means I have to stop sharing screen, then I start another screen. So let me just quote from another pad. Quote, Section 14 of the Ordinance Law provided that the common law, doctrines of equity, and the statutes of general application, which were enforced in England at the date when the colony obtained a local legislature, that is to say, on the 24th day of July, 1874, shall be enforced within the jurisdiction of the court. So, if you go back to UK during the colonial days, you know, the Parliament of Britain, or the Metropolitan Parliament, as it were, and it was make two types of legislation. One legislation meant for the Britain or England and Wales, and later on aspect of Scotland itself. And then another set of legislation, what they call the legislation of general application. So legislation of general application meant that it was applicable within all the colonies. All the colonies, not only Gold Coast, Nigeria, India, wherever the British Empire expanded at the time. So that is the idea of the Statutes of General Application. But as a colony matured in terms of laying foundation for its own legal system, like we had in Ghana by 1876, when our local legislative council at the time passed the Supreme Court Ordinance of 1876. Among the sources of law, it decided to provide what they call like a cut-off point. In other words, the statutes of general application, which had been made ever since British Parliament started the colonies, right up to 24th July 1874, were meant to be applicable in Ghana. And what that means is that after 24th July 1874, any statutes of general application was not meant to be applicable to the Gold Coast, because the Gold Coast had its own assembly, legislative council, and is able to make a laws for itself. So that remember 24th July 1874. So this is one of the rare type of question in which you either know it or you do not know it, and then there's a very little room for speculation. Now, there is an article which Professor Kwashiga has done, and if you look at some of the questions, you can sometimes see the thinking of Professor Kwashiga reflected in them. So it is wise to read that article, just in case he happens to be like the person who is also setting some of the questions. So his article is titled "The Historical Development of Legal System of Ghana, an example of the coexistence of two systems of law." So we put that article on the platforms which I have. So if you belong to any of them, I'm sure that you'll be able to read it. There's a very short and useful as far as a good revision on the basic historical aspect of a legal system is concerned. So if you could just look at that, I think that is very fun. That was published in 2008. So I'll put it over there. The Bond of 1844 and all those things are discussed. And you could see that most of the things which matter as far as basic history of legal system are concerned there. Now let's take, let me look at the answers that some of you provided. Before, let me look at the answers. Yeah, I'm teaching online. Yeah, so, okay, so, hey, somebody said C, another person said D. Good. Now those who said D, can you actually explain why you think that that question, the answer is D, not C? I'm talking about question 1. The person who went for D. I'm interested in getting your explanation. So if you don't mind, you could. Is that Yaya? Okay, let me ask you to explain. Yeah, Yahaya, I've released you. Go ahead. Yahaya, is your hand up or just by accident? Maybe he doesn't. That is okay. Let's move on. So the bond of 1844 was primarily designed to achieve the following. Of course, another important foundational material, when you're talking about history of Ghana legal system, is the bond of 1844. Because the bond of 1844, if you like, is one of the very first primary constitutional document, as it were, because it gave a legal foundation to the position or the authority, which was being exercised by George McLean and the company merchant, as it were. And of course, later on, Commander Hill, who was then the Lieutenant Governor General, was able to formalize the arrangement which George McLean and had started. So if you look at the bond of 1844, what was the purpose? What was it supposed to do? So let's look at the answers. A, protect the signatory from wrath of the Fante gods. Certainly no. I mean, some of this, when you read it, you'll be able to rule it out yourself, isn't it? How can a law protect someone from something spiritual? So if you're using the elimination method, even if you don't know the answer, you're using the elimination method. I think it's something that we can easily work it out, isn't it? A law certainly cannot protect one from something spiritual. So A is out, and B, you don't even need to waste your time. As soon as you see the gods, and the law, you will certainly have to root. So now you have to contend with C and D. C and D, one of them is going to be the correct answer. So let's look at the C. Alliance of the coastal states against Ashanti. D, to extend British dominion over the coastal states of the Gold Coast. What was the correct answer? Look at your text. D, we still have people going for D. Yeah, so those who say D and those who say C, what is the reason for your explanation? So let me quote what the bond, among other things, sought to do. The first of a succession of treaties under which certain Gold Coast chiefs acknowledged the power and jurisdiction of the crown and gave their formal consent prior of criminal cases before the Queen's judicial officials and chiefs of the district, molding the customs of the country to the general principles of British law. So, extend British dominion over the coastal states of Gold Coast, alliance of the coastal states against Ashanti. Is not necessarily alliance. Of course, that in a long run, that could be one of the purposes, but the main purpose was to extend British dominion over the coastal states. Because don't forget that initially the authority of the, what do you call the company merchant, that is the traders, the British traders, it was just the force and the castle, as it were, and it did not extend beyond the forts in the castle. So later on, how to legitimize over the areas beyond the forts and the castle, that was the idea. Of course, the alliance of coastals against Ashanti was secondary, but not the primary, purpose of the bond of 1844, as it were. And if you read the literature, the various, Yeah, I think my line went off momentarily. So let us go ahead. So those who opted for C, can you explain why you went for C? Yeah, those who opted for C, can you explain why you went? You can put up your hand. Let me see. Nobody's hand is up. Okay, let's move on. Okay, so the common law of Ghana consists of the following elements. So again, here, let's assume that we don't know the correct answer, and you need to use the elimination method. As soon as you hear of the common law of Ghana, you have to know that we are speaking in terms of observing of the constitution. And the common law of Ghana is a term of art in the sense that the common law of Ghana is broader than what is generally known as the common law. What is generally known as the common law is part of the common law of Ghana. But in addition to that, there are some other things, especially the customary law. So that is one thing that we should keep in mind. So we look at the common law of Ghana. Let's go through the them. Received English law. Received English law, doctrines of equity and customary law. Now, if you look at that option, it is fine, but the only problem is that insofar as you have just received English law and then the doctrines of equity, that is what makes it complicated. If it had just been the received common law and doctrines of equity and common law, that will make it very simple. A is a high candidate, so let's flag A. B, receive English law, doctrines of equity and rules of natural justice. You have to note that certainly that is not it, because rules of natural justice is actually part of doctrines of equity and also the receive English law. So B is out. Receive English law, commercial law, and custom, not repugnant to natural justice. Certainly, if you remember your Article 11, you also have to know that that is no, 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 no. Because why have you singled out commercial law? So C is out. Received English law, as at 24th July, 1874. Customs not repugnant to natural justice and laws of the colonial legislature. Now, D may deceive you, but D is not the answer. Because now, if you talk about the common law of Ghana, unless the question had limited you to the Supreme Court Ordinance of 1876, but if the question simply says that common law of Ghana, then our understanding of what it is should be from the Constitution, that is Article. And then the Constitution will explain common law of Ghana, being the common law, doctrines of equity and customary law. But here, we will just substitute receive English law for like the common law. So receive English law, so that is like the common law, the doctrines of equity, and then the customary law. So therefore, A is the correct answer in the circumstances as it were. So you see how sometimes when you get it, you are convinced is the correct answer, go and shade the answer. Just exercise a little bit of patience and run your eyes through the rest of the option just to make assurance, as somebody said, double sure that your preferred answer is obviously the most correct one. Yeah, so that is what because when we read it, one might have just settled at A. And that will be the answer, but just you don't lose anything if you just decided to test the correctness of your chosen answer by looking at the other options. And that is why I would suggest that it is a good strategy MCQ when you get the correct answer to also look at the rest of the as it were. Okay, we come to a little bit of legalities or or Latinate expressions. The Latin term de minimis non curat les. Somebody will ask, so how can we know which Latin expressions are going to come? I mean, it's very simple. If you have been taking the basic module serious, you notice that certain areas of the law, there are certain common expressions. And those expressions, if you do well to know them, I mean, that is good. So let's say that if you take any of the 6 modules, you take legal system, you come across, of course, audio audiotarian pattern, which is part of a natural law, isn't it? No more you das in casa sua. You have to understand what it means. So, for example, if you did not see de minimis non curat and he said that the audio audiotarian pattern means you have to know that it says that they hear both sides, listen to both sides, or hear both sides of the matter before you judge. Or if you were given nemo judas in casa sua, it simply means that the rule against bias, or you shall not be a judge in your own cause. You shall not preside over a matter in respect of which you have an or so maybe like the legal system. Legal system, what are some of the other Latin expressions? Habeas corpus, for example, produce the body, literally, as it were. Certiorari is a prerogative rate or order seeking to quash a decision which has been given because in a way which is contrary to other principles of natural justice, or in a way which is so irrational in terms of Wensbury and reasonableness, or is improper exercise of discretion, as the case may be. Yeah, so just be familiar with some of the common expressions, like the Latin one. Legal system, again, you can still talk about the stare decisis. Stare decisis, that is stand by settle matters, or do not hear with matters which have already been settled. Then you come to, let's say, contract. You also have to know some of the common Latin expressions which are there. You've heard of a consensus addendum in the very expression. That is the meeting of what? The meeting of minds. That means that before there can be an agreement, the minds of the two parties have ought to have met on the subject matter or whatever the contract is about. Or the authoram pattern. Maybe you come across a pacta sunt servanda. Pacta sunt servanda. Pacta sunt servanda simply means that agreement is supposed to be obeyed. You don't have to breach or undermine a promise. So all that I'm trying to say is that each subject area, because of this, like a type of question, like maybe you are given a certain Latin term. For example, in those days, if you had like a Justice Tukuba, Justice Tukuba, who, for example, was setting the question, is somebody the for Latin and legalis. So at least you throw in one of this. So just know some of those things, and I think that you will be you will be fine. Maybe like contract, for example, you can say contra proferentum. Contra proferentum. So let's say that in contract, if you say like the contra proferentum, if the question said like the what is the meaning of or contract proferentum means that you simply have to remember that we are talking about the rule which says that where there's an ambiguity in the contract, especially like exemption exclusion clause, is supposed to be interpreted against the person at whose instant that at whose instant the exemption clause was included in the contract. So we see how we have also used Latin expressions from contract. Or you may be giving force majeure. Force majeure. Force majeure, that is what you call like an act of God, right? You have a contract and you say that on occurrence of certain matters which prevent performance of it by force majeure. So we see how, in contrast to, we can get some examples of this Latinate expression. Then we go to thought. If you go to thought, there are so many of them. Res ipsa locuto. Res ipsa locuto. Res ipsa locuto simply means that the matter speaks for itself. That is the fact that something is present is an evidence of a negligence having been committed as it were. Or we can talk about some, apart from res ipsa locuto, what thing readily comes to mind in thought? Anybody? Let me look at the chat, what you're putting over there. Okay, non-nest factum, okay? Non-nest factum is a thought, as a contract. That is not my deed, or it is not my act. And it's a defense which is pleaded to actually escape from the effect of the rule of what we call a parole evidence rule, right? Parole evidence, where you're being held to the written document. Inappropriate, so we can say that they're known as factum. Voluntar non-fit injura. Okay, voluntar non-fit injura. That is a voluntary assumption of risk. Voluntary assumption of risk. Novus actus intervenus. That is where there's a new thing which has break the chain of causation. When something is interposed between the breach of the duty of care and the ultimate injury which have been suffered. If there's a break in the chain, then we talk about like novus actus intervenus, as it were, and so on. So somebody has also said that the S2P causa non orito. That is, you cannot find an action on basis of an illegality or a base thing. Yeah, so ab initio right from the beginning. So the Latin expressions are just, so just the common ones. That is all that I'm trying to say. And that is why you'll be giving this example, just the common ones. And I think it should be fine. So let's come back to question 4. De minimis non curat less means A, the law is interested in small details. Now, if you know a little bit of, sorry, my, but I am back. Yeah, so you notice that if you see the word none, none simply means that not. So A will certainly not be the answer because of the not. The law is interested in small details. No, the law is not interested in small details. B, the law does not concern itself with trifles. Yes, that is the most likely answer, but don't let us stop there. Don't let us stop at the B. C, the law does not concern itself with inaccurate details. No. D, the law is interested in accurate details. Now, the law is interested in accurate details. That is not the meaning of the that's not the meaning of the de minimis, because as soon as we see the none, then it's supposed to be like a negative. So A and D are all positive statements. For that matter, they are ruled out. A is a positive statement. The law is interested in small details. So that is no. And then D, the law is interested in accurate details. That is also no, because it's a positive statement. Then let's, so we have to juggle between B and C, assuming we did not even know the right answer. Let us juggle between using the elimination principle. So the law does not concern itself. Trifles. Yes, it's a negative sentence, so it's a good candidate. And then C, the law does not concern itself with inaccurate details. You see the inaccurate details, and you should know that that is really usual. So C is not the answer, and the correct answer is B. The law does not concern itself with trifles. So that is a de minimis non curat less, or what they call the de minimis principle. So it's not like the tiny matters. Just like maybe you have a contract, just a tiny insignificant, inconsequential, insubstantial breach, and then you drag the other party to court for, that is, you be met with the flag, de minimis non curat less. We are not talking about pettiness. We are talking about significant huge things. Okay, now, let me look at the chart. I think some of you have put some stuff there. Okay, so yes, C, yes, C is correct, Joe Biden. Okay, so the 5, the rule of law in its owes a great deal to. So this is another type of challenging question as whether you know it or you don't know it. And that this is what requires you to have taken your constitutional law and the general Ghana legal system and legal method serious. So rule of law, when we talk about rule of law, set in the modern sense, owes great deal to A, Lord Denning. Lord Denning has made significant contribution towards the law, but law, do we often associate, if you are probably, if we said that the doctrine of promissory estoppel, right? The doctrine of promissory estoppel, let's say in modern sense, owes a great deal to Lord Denning, I will agree. Despite the fact that in the House of Laws, in the, what is the old Metropolitan Railway, as far back as the 1876 thereabout, had actually propounded the estoppel doctrine, not Lord Denning, who in the 50s actually made it popular. So if, for example, you said that promissory estoppel, I agree, is Lord Denning, but rule of law, no. I wouldn't go for Lord. Baron Montesco. Montesco, law, rule of law, Montesco. Certainly no, certainly no. If Montesco, you are talking about maybe things like the separation of powers, right? Separation of powers, some aspect of constitutionalism, checks and balances. I'll go for Montesco. And then I bet Dicey. A.V. Dicey. A.V. Dicey, his name is synonymous with rule of law, at least in the most of the basic literature. So you certainly go for him. And then William Blackstone. Now, William Blackstone, if you are talking about like the common law, if, for example, we said that the common law owes a great deal to Blackstone, I will go for that, because Blackstone, in his various treatises, in his writings and all that, brought some kind of systematic organization of the scattered principles in the various cases. And that way gave some kind of a structure or coherence to the common law. So I will associate Blackstone with maybe like the development of the common law and things like that, but not necessarily with the rule of law. Yeah, so that is what I would keep in mind. Let me see. I think some of you have. Oh, I put something in the chat. What have you put there? Okay, good. Joshua Abba, thank you. Albert Van Dicey, 1835 to 1922. Okay, that is. All right, good. Good. Then let's move on. Question 6. So we are getting into the area of law of thought. And that is why I said that this exchanges enable us to talk around a lot of areas. To what the term vicarious liability refers. So as soon as you hear of vicarious liability, of course, your mind will go into the realm of law of thought. Your mind will go into the master-servant relationship. Your mind will go into the realm of employee-employer relationship, principal-agency relationships, as it were. So vicarious liability, what does it mean? vicarious liability is a principle. Yeah, okay, Daniel Saki, your hand is up. Okay, let me allow you before I continue. Daniel Saki. Daniel Saki, you want to put up your hand? Okay, Daniel Saki, yes. I've released, we can talk. Daniel Saki. Or was it an accident? Okay, if you're not talking, that is fine.
Hello, sir.
Yes.
Yeah, so vicarious liability is basically a principle. It's a principle in tort and general negligence, which states that an employer is responsible for the negligent conduct or negligent tort that has caused an injury to a third party.
Right.
And the court will consider if, at the time of the negligent tort, automatically the employee has to be working within the scope of his employment before the employer will be probably liable.
All right. Okay, thank you very much, Mr. Saki. Yeah. So in the light of that, let's discuss Joshua Abba. Joshua Abba, yes, you can speak.
Yeah, Doctor, thank you. Having said that, by my learning colleague, the employer has to provide a proper working to.
You have to be careful not to say learned colleague. You don't have a learned colleague yet.
Okay, thank you. But the proper tool for the employees to work with is also a factor that the court will consider.
Okay, so all right, thank you very much. So first of all, we need to understand the concept, and then some of you have also included the tests or how we are able to establish whether the proper relationship exists for invocation of vicarious liability. So vicarious liability, yes, someone has committed the tort, and the person who has committed the tort is called the tortfeasor. So the person who committed the tort is a tortfeasor. Now the tortfeasor is not going to be held liable personally for the tort that he or she has committed. Rather, another person is going to be held liable. And the person who is going to be held liable will be the employer or will be the principal, as it were. And you need to establish whether the tortfeasor committed the tort in the course of employment, in the course of performance of his official duties for whoever had employed him and all that. Now, if that is the case, then his tort will be attributed to the employer or to the principal, as it were. Just like you have someone who is working as a doctor, let's say at the 37 military hospital. He does not do his work well, and then he creates injuries to someone. The person would like to sue for medical negligence. The doctor who attended to the patient may not be sued directly, or if he's sued at all, he may just be made like a co-defendant, and the employer, that is the hospital or the management, will be made like the main defendant because of the principle of vicarious liability. So therefore, let us look at the options and pick the most suitable answer. And I emphasize the most suitable because when it comes to multiple choice, now law is not mathematics. Law is not mathematics in the sense that most of the things are somehow inexact, so they are subjective. And for that matter, we are interested in like the most correct among the competing options. So that is the emphasis. So to what does the term vicarious liability refer? A, the liability of ministers of certain religions. You get an option like that, and right away, it should sound funny to you, isn't it? Liability of ministers of certain religion, just that. That is a bit problematic. Of course, if you are a pastor of a church and you have committed maybe defamation, or you've committed some other thoughts, your church will be held vicariously liable, especially if you committed it in the course of doing your work as a minister, as it were. But we wouldn't right away settle on A, because A is too hanging, and we don't have enough information for us to be certain as whether A is the most accurate response. So let's go to B. The liability in nature of a punishment for a blatant infringement of another's right. The nature of punishment for blatant infringement of another. Is that vicarious liability? No, certainly not. Certainly not. C. Liability of an employer for acts committed by employees in the course of their employment. That sounds more closer to something which is likely to be the correct answer. So let us flag C. The liability of an employer for acts committed by employee in the course of the employment. You notice that all the explanations that the various contributors have given regarding various liability are reflected. The fact that there's an if like employee employer relationship, or master servant relationship, or principal agent relationship, as it were, and the particular act was committed in the course of the person's employment. Of course, we have to remember that if the person was an independent contractor, then vicarious liability will not be applicable. So you have to note that. So for example, the question has been that vicarious liability applies to all the following, except, let's say you have an employee, you have like a servant, you have agents, you have independent contractor. You have to note that the answer will be independent contractor, in the sense that vicarious liability does not apply to independent contractor, because that is his own boss. So when he commits any wrong, he or she bears personal liability. But if an agent commits a wrong or a tort in the course of his agency, it could be visited, attributed to the principal. The same thing applies to a servant. If a servant is attending to the affairs of the master and he commits a wrong, that can also be applicable to the master. But independent contractor, no, because he is his own boss, as it were. So he will bear personal liability or responsibility, as it were. So let's look at D, the liability of employees for acts done on their employer's behalf. So now the answer will have to be juggled between C and D. They all appears correct, but one is more correct than the other. So that is what we have to emphasize. So the A and B are out. So now we have to juggle between C and D. So let's look at D again. The liability of employees for act done on their employer's behalf. No, because we are talking about the employer bearing the liability for something which the employee has done. So if you don't open your eyes and read well, if you look at the D, it sounds somewhat correct in your ear, but it is a wrong answer. The correct answer is C. The liability of an employer for acts committed by the employee in the course of their employment. And just I like to get to the basics of things. Let's take vicarious liability, right? The word vicarious. The word vicarious comes from the word vicar, right? When we say vicar, because I'm a Catholic, I use the Latin or the canon law language to explain. So vicar means that the representative, like the agent, we say like the Pope is a vicar of Christ on earth, is an agent. So when we say like a vicar A vicar is like if like your deputy or your representative. So vicarious liability. So your representative has done something. Your representative has a burden, and that burden or that liability is being attributed to you because he is representing you. He incurred that while representing you. That is why we have the expression vicarious liability. Yes, the person who is called barrister, you are released to talk. I hope that when the General Legal Council get to know your barrister already, do not allow you to write this examination.
Thank you. Good evening, Doctor.
Good evening.
Doctor, when you're talking about the vicarious liability, you said that independent contractor, the employer will not be liable for tort committed by an independent contractor. But I can remember there are some exceptions, and one was that if the employer was negligent in choosing or in, engaging the independent contractor,
Then there's a bit of
he may be liable for.
your sound quality is not very clear. The sound quality is not very clear. So if you can write it in the chat, there's a bit of like
Hello.
echo. Yes.
Is it clear now?
Yes, it's clear now.
Okay, so I was saying that you mentioned that, or you stated that for the vicarious liability, when you were talking about independent contractor, you said that the employer will not be liable for the tort of an independent contractor, that it is only for employees. And I'm not saying that. I learned about some exceptions to the effect that the employer will also be liable for the tort of an independent contractor in some circumstances. And one of those circumstances was that where the employer was negligent, in choosing the independent contractor who is not maybe competent to carry out the job. And another one was that when the employer, specifically or expressly authorize the independent contractor to commit a particular tort. I think those are some of the circumstances in which the employer will be liable for the tort of an independent contractor.
Well, apart from maybe having maybe with the occupier's liability, right? Let's suppose that independent contractor has come to your premises to do certain work, and maybe that independent contractor has, for example, created certain dangers while on your premises, and he leaves, or another person comes to that premises, and that person is not alerted as to the dangers which have been created on that premises, and then the person sustains an injury. So here you have some kind of like intermingling between occupier's liability and also this idea of vicarious liability. Now, because the employer is the person in charge of the premise, and depending upon the category of the visitor the person was, if it was or something like that, then the employer who is responsible is also the owner of the liability. That's why the danger that is caused by yeah. That's why the fact that the danger there was caused by the independent contractor, but that is a very unique situation. Otherwise, the fundamental and the traditional common law principle remains that the tort of independent contractor cannot be vicariously attributed to the person who awarded the contract to the independent contractor. No. So let's look at the 7. Person who in the course of a non-natural use of land accumulates or is held to be responsible for the accumulation on it of anything likely to do harm if it escapes, is liable for the damage to the use of the land of another, which results from the escape of the thing from his land. Then the question is, what tortious is not tortuous, it should be tortious. What tortious principle does this statement represent? Of course, if you'll be revising your thought as soon as you read something like this, you notice that we are referring to the rule in what? Balance and yes, the rule in Bradford Corporation and Pickles, certainly not. The rule in Smith and Sloan, which is my favorite principle. What do you call it? The double felonious principle. Remember the double felonious principle? Who remembers double felonious principle? Double felonious. The double felonious principle simply means that where a tort has been committed and it is also a crime, originally, the double felonious principle meant that if if the tort is also a felon, that is a crime, then you need to prosecute the crime first before pursue the tortious aspect of that same incident. So that's what we call like the double felonious principle. So in the past, according to the rule in Smith, that will mean that if, for example, there was an accident, it was a careless driving, at the same time, is also negligence, like a breach of duty of care and all that. The rule in Smith and Sloan, the principle, we say that you need to prosecute the careless driver for the offense of careless driving before you come and pursue the civil liability aspect of that same incident. So, but certainly that is not what the above statement relates to. So that is out. The neighbor principle in the Donoghue and Stevenson, that is also out, because remember the famous Lord Atkin principle concerning the general imposition of the duty of care, that the categories of duty of care are not close. Remember the case of the Crane, Christmas, and Carol, where in those cases, the position of the law used to be that if someone had actually caused injury to you and wanted to bring a negligence action, needed to be able to fit your situation into one of those limited instances in which the court have held that negligence actually can be founded, or someone owed the duty of care. So the duty of care had been held to be owed in a very limited or limited number of instances. But we remember very well, I think was it 1932, when Lord Atkin, in his famous neighbor principle, that whenever there is that proximate relationship between you and another, that you should have that person in mind. Otherwise, if your action or mission should cause an injury to that person, then you could be held liable. So where there's that proximity, then a duty of care will be owed. So this was quite a landmark in the sense that it's actually been a new vista, or created what they call a general principle for recognizing existence of care, unlike the pre-Donoghue and Stevenson position. So the pre-Donoghue and Stevenson position was that there was no general duty of care, that you could only make a claim that someone had breached a duty of care if you could point that particular instance to one of those limited categories in which the court had previously concluded that a duty of care exists. But Donegal and 1722, as you remember, Lord Atkin actually radically transformed this area of the law. And that has been developing through to so many important principles. Caparo, Dickman, LeBron, Helen Partners, and all that up to date. Good. Then we have like the rule in Rowlands and Fletcher. The rule in Rowlands and Fletcher, a very old case, and the rule in Rowlands and Fletcher. This was decided in 1866, right? Now, in 1866, there was no general principle of negligence. So, the general principle of negligence, which you got to know post 1932 in Donegal and Stevenson, was not known there. Now, if the general principle of negligence were, for example, the rule in Rowlands and Fletcher would not have been very important, because if you have brought something which is not a natural user, that is something which is not normally found in that particular premises, and it is, if you like, strange in terms of the fact that that particular land, that is not something which is supposed to be found there. You collect it there and you don't keep it under control. It escapes from your control, and then it causes injury or causes harm to another person who is near to you in terms of like his life joining you, then you are going to be made liable. So that was the Rowlands and Fletcher. And you remember like the story of that. Who can tell us about the real story of Rowlands and Fletcher? Who can tell us about the real story of Rowlands and Fletcher? Somebody has asked the question whether I can explain the various schools of thought regards vicarious liability with emphasis on the course of duty. The person who asked that question, are you talking about the method of establishing whether vicarious liability exists, or are talking about the question that the other gentleman brought up? So if you can actually let me know. If you are talking about like the tests, as well as what you call like the control test, the test, integration test, and all that. If that is what you are talking about, then that is fine. We can explain. On the other hand, if you are talking about the other issue which the other gentleman raised concerning what he claimed is the exceptional instance in which you could actually apply vicarious liability to independent contractor. So if you can clarify so that we will explain. But if you are talking about just the various tests as to how do we determine whether there exists an employer-employee relationship between the parties, then we can talk about that. So just let me know. But just in case you want us to go through that too, we can also spend some time, or otherwise I'll put them on the platform for you and then you can look at that. We have a few minutes and then we end the class. I don't want this to be lengthy since we have to be going to work. Okay, so of course we look at a question like question 8, for example. I mean, which is not really just one of those things you should throw in just worry students. It's not really academic, isn't it? How many core courses must a student currently pass in order to be eligible for entry in the Ghana School of Law? I mean, this is funny. This is not academic. This is just like, anyway, so you know this. So I'm not going to waste my time to discuss this type of question with you. Okay, let's move on to the proper law question. What is a thought actionable per se? Okay, so when we say that the a tort is actionable per se. We are talking in the area of defamation, and you have to remember that mainly. But because it did not talk about did not just defamation and then just brought it, just taught in general. So when we say something is actionable means that you can bring an action, you can sue, right? You can, and when we say it is actionable per se, that is to say that you can sue without proof of any actual loss, right? You don't need to actually prove that you have suffered a loss or injury before you can sue. That's why I say that it's an actionable per se. So let's look at the, okay, so a tort that's actionable without proof of any actual loss. A. B, it is a tort where no evidence of how the damage occurred is required. C is a tort that is actionable only where damage is actually shown to have occurred. And D, it is a tort for which there is no defense. Of course, we see some of the answers appear close, but we can weed out the chaff. So let me look at the responses that you have provided in the chat. Okay, so we have, I think, almost everybody is talking about E. Okay. All right, so nobody has opted for any different type of. Yeah, okay. Yeah, so as I said, is the just like if we're talking about like a defamation, if you talk about you have a libel and then you have a slander, and it is in the realm of the defamation that we often talk about, like there is an actionable per se. But because defamation, I have the feeling that it will not be out of place to test you on defamation, especially defamation on the social media, right? So we will need to do a little bit of discussion and we brush up the defamation. So I think that if in the area of tort is one, I think the potential area that you could be examining on. So you should pay attention to defamation as well this particular year. I'm not saying it's going to come. No, I'm not saying it's going to come. I'm just letting you know what it is. Yeah, then question 10, they threw in, yeah, of course. Just before we rush on to question 10, I think let's dismiss the rest of the options in the question 9 we're looking at. It's a tort for which there's no defense. Is there any tort in which there is no defense? Absolutely not. Every tort, you could have one defense or another. Of course, even if you're talking about straight liability, right? If you're talking about straight liability in criminal law, you can have like a defense. So there's nothing like a tort for which there is no defense. So that one is certainly out. They say there is a tort that is actionable only where the damage is actually shown to have occurred. No, that is the opposite of what the question is actually talking about. So you have to juggle between A and B. It's a tort where no evidence of how the damage occurred is required. If you look at A and B, one would argue that they are essentially the same, right? They're essentially the same, But because the examiner did not frame the responses with the necessary neatness, so you will settle with A as like being like the most accurate in the circumstances. Now let's come to question 10, subprime mortgage. That is a question which is out of the blue, because although we are supposed to learn mortgages law, mortgage and pledge, right? Customer pledge, as it were. But this is not something that is usually part of the mortgages law that we learn, and it is more to do with like those who are in the area of like the investment. But that notwithstanding is a question which has come, so we need to apply our mind with. So what is a subprime mortgage? A subprime mortgage, making loans to people who may have no difficulty in maintaining the repayment schedule. B, making loans to people who may have difficulty maintaining the repayment schedule. C, making loans to people who are unemployed. D, making loans to people who are buying their first property. Yeah, so as I said, this is a question that a student in Ghana can easily get it wrong unless he's someone who is in the area of investment or the real estate. But if we look at the Investopedia, that is the information on the and all that. When you talk about the subprime generally refers to below average credit score of the individual taking out the mortgage, indicating that it might be a credit risk. That is those who have, if you like, a high risk of defaulting. That is the meaning of a subprime. And for that matter, if you apply it to mortgage, then it will explain that the interest rate associated with the subprime mortgage is usually high to compensate lenders for taking the risks that the borrower would default the loan. So the takeaway is that subprime mortgage is for people who are at the high risk of defaulting or of not being able to repay according to schedule. So let's go through the options and pick the right one. Making loans to people who may have no difficulty in maintaining a repayment. So based upon the explanation that we got from Investopedia, we could say that the answer is not A. B, making loans to people who may have difficulty maintaining the repayment schedule. So B is close, so let's flag it and then see if that will remain the ultimate answer. C, making loans to people who are unemployed. Of course, if you're unemployed, definitely you're high risk. You'll not be able to pay. But will anybody even give you a loan if you're unemployed? So that is the other thing. D, those people who are buying their first property, no. So A is out, D is out. We have the jargon B and C. But if you are going by common sense understanding, one would say that if someone is unemployed, you are not going to give a mortgage to the person, and that is out. Definitely give a mortgage to someone who has got some kind of like an income stream or revenue or income flow. So B is the most accurate answer in the circumstances. Let me check what some of you put down. Okay, so I think almost all those who responded also went for B. Now I think in just about 5 or 10 minutes time we'll be ending, so don't worry, so that we continue tomorrow. Tomorrow we will start at 9 instead of 9 because I'll finish my teaching at the university at 9. So by the time I get home, 9:30. So, but we use the same link. We're going to use the same link for all the everyday lectures until we are advised otherwise. So let's apply some of the things that we'll be discussing to this interesting question. If your neighbor insists on smoking tilapia in the home make grill, and the smoke smells and smart from the grill drips onto your property, dirty your washing and stop you from sitting on your porch in the evening, which of the following will be appropriate thoughts in which to sue your neighbor? Yeah, that is very interesting. So you remember Rollins and Fleischer. And Rollins and Fleischer, one of the things that should always come to your mind is what they call like the non-natural user. Non-natural user. So will you say that smoking tilapia in the homemade grill, is it a non-natural user? No, not, okay, let's go. Nuisance, yes. Nuisance, because that is interfering with your enjoyment of your land. So yes, the smoke making it impossible for you to sit in your porch, isn't it? So that is more likely to be the correct answer. See, trespass. Trespass as a person interfered with your possession, with your title. Or no, we cannot necessarily see that. D, negligence. Negligence. Duty of care. You could, if, for example, of course, negligence, you should always be able to establish the three things: existence of duty of care, breach of duty of care, and then the resultant injury or the resultant damage or the consequent damage. But if you look at the circumstances of this case, we may not be able to get all the three elements present. And for that matter, we have to weed out negligence. Because the duty of care, can we locate who somebody duty of care? Okay, if you can get that, is there a breach of that duty of care? Is there a resultant injury? Ulu said that you not being able to sit on your porch, is that the resultant injury? No. Insofar as we have the most direct and relevant, which is a nuisance, that will be the correct. So as I am ending here, I'm going to allow you to ask a few questions, and then we'll draw a curtain on the day so that you can go and rest. So quickly, question 12. At common law, a master owes a duty of care to his workers. What does this duty entails? A, provision of social amenity, land-based and health insurance. B, provision of nursery, of course, I mean, that one, provision of a nursery for nursing mothers and maternity leave. C, provision of competent staff, adequate material, proper system, supervision. D, provision of bonuses at the end of the year. So if you don't even know the answer, you can easily know that we are talking about C. Because if you are talking about the common law, what the master owes to his workers. Health insurance. These are matters which are later additioned by the statute law, right? Even lunch breaks. All these things were provided by the Labor Act, and they are not common law creation. They are creatures of a statute law, the Labor Act or the labor legislation. And B, provision of a nursery for nursing mothers maternity leave. Yeah, this is also, if you like, an aspect of the Labor Act and also Children's Act. And that is not like the common law. So A and B are out. Then you come to a D, provision of bonuses at the end of the year with a Christmas party. Certainly, this is a fanciful and a wishful thinking. And I mean, this is, you can easily dismiss D. Bonuses, no. Then C, provision of competent staff, adequate material, a proper system and effective supervision, yes. So that is what a master owes his workers at common law, to ensure that he employs other working colleagues, other staff who are competent. He makes available the requisite material needed to get the job done. And then the system, that is the arrangements for doing the work to properly established. So that is what is expected of the master to his common law. And of course, effective supervision as well. Okay, 13. I wanted us to really exhaust this, but because of the time, we cannot exhaust them. And then we look at the essay questions as well. So we'll continue another time. But my preference for using some of these questions for the discussion is that it sort of like opens up a lot of possibilities for us to revise. Yeah. So I'll end here and then take questions. Maybe 5 gentlemen, 5 ladies. Short. And then somebody said, can we solve the 12 question at a faster pace? As I told you, solving the question per se is not my motivation. My motivation only lies in the question providing opportunity for us to discuss different things at the same time as part of the general revision. If we're just solving the question, I could just do the answers and then just put them there for you, isn't it? But that is not the point. Let's do. We take you.
Yes, Professor. Thank you. Good evening.
Good evening.
Yeah, quickly, my question is about the subprime mortgage. I want to know under what circumstance would one, knowing very well that the person he is being granted a loan would have difficulty in payment. Yes, I'm just inquisitive, just to know.
No, Alex, as I told you, I personally, I think that one of these red herrings or one of these detractors, which was put in your question, because of in land law or succession, you do a bit of like, we do mortgage law and all that. The kind of mortgage law that we do, we are more interested in the legal aspect rather than the economics, like the aspect. And then the subprime lending or subprime mortgage is definitely taking us into the economic aspect. But as the explanation that I read from the material that I chanced upon indicate that it's where the person that you are giving the mortgage to is a high risk in terms of a high risk of default. And for that matter, the interest rate is very high to actually compensate for the risk which the person creating the mortgage is assuming, as it were. So let's do it. So those are the few things I can share on that. But if you like more about investment ideas, I think you push more materials and then you read on them. Thank you. So we come to
Very well said. Thank you.
Joshua Abba.
Yeah, Prof, thank you. Prof, my question has to do with our nuisance. Is it applicable to all community? I'm asking because the smoking tilapia question, which is question 11. For instance, another person also processing fish, fresh fish to dry fish, and the smoke also affect, let's say, a third party. Is it applicable to all community, Doc?
No, I think fundamentally what you should remember about nuisance is that which protects
all this thing will be waste.
Protects your interest enjoyment of the land that you have ownership, you have authority of whoever is the owner is. So where your enjoyment of it is interfered with by another person's activity, of course, then you can make a case of a nuisance. But then we also have to distinguish between a public nuisance and then a private nuisance. Yeah. Okay. Yaya. No, Yaya has taken. Let's take Eric Ofer. Eric Ofer. Good evening, Eric.
My question is, how does vicarious liability compare with employer's liability?
Please, your sound quality is not the best.
Is it better now?
Yes.
Then how does vicarious liability compare with employer's liability? Because in one of the submissions made by brothers, he indicated that an exception. Hello?
Yes.
Yes.
Your sound quality is not the best, but we are managing. Yes. So you want to find out the relation between employer's liability and vicarious liability, right?
Yes. Yes, please.
Right. So vicarious liability is a subset of employer's liability. Vicarious liability simply means that an employee, in the course of carrying out his employment duty for on behalf of his employer, has committed certain acts. And instead of holding that employee personally liable, you rather hold his or her employer liable. So that is a vicarious liability. But employer's liability relates to everything connected with the employment. And that is why I said that vicarious liability is a subset. That is the wrongs committed by his employees in the course of his employment. He bears the liability. And of course, other things also related to his duty as an employer. You are supposed to pay taxes, you are supposed to pay Senate, you are supposed to pay all that. All those things are part of your liability as employers. And that is why I said that employer's liability bigger than vicarious liability. Vicarious liability is just a subset of employer's liability, if you like. Okay, so just a few minutes, you ending. Joe Biden. Joe Biden, 30 seconds, yes.
Hello, sir. Good evening.
Good evening.
Yes, sir. Please, I would like to add under nuisance, at what point can a claimant bring an action against the defendant? Must the event happen once, or must the event must happen consistently, or once the event happens once, the claimant can proceed to court for an action against the defendant?
Right. Okay. I think that there's no hard and fast rule in terms of the occurrence of the event you are complaining of nuisance. However, for evidential purpose, that is, in order to get the evidence able to substantiate your claim, if the occurrence is more than one, it becomes relatively easier. Or if it is ongoing, isn't it? In which case, sometimes we can even get an order for abatement and all that. Yeah, but otherwise, there's no hard and fast rule that if the interference was just one occasion, it cannot give rise to nuisance. No, it can. But as I said, the more frequent interference, the easier it becomes for you to get the evidence to establish the nuisance. Okay, so let's take Yahaya, 30 seconds, and then we're done.
Okay. Thank you, Mr. Oso. So, I want to find out, in citing a case to support, your answer, for want of time, how many cases do you think are, sufficient? And then apart from the holding, what are the other relevant portions of a judgment that you need to state, sir?
All right. So if you are dealing with it depends upon the type of question. If you are dealing with essay question and you are writing your essay, you need to be citing cases. Essay is usually an invitation for you to demonstrate your understanding of the law in terms of its development or in terms of areas of it which may need reform and things like that. So that way, you need to recite as many authorities as are relevant to the discussion that you are doing. On the other hand, if you are dealing with a problem-based question, as I have told some of you during some of the previous interactive sessions, is that when you are dealing with a problem-based question, what we call like they're using the IRAC, you are supposed to behave like a lawyer. And what do I mean by that? You are supposed to apply the law as is the law currently enforced, and not the law which was there in the past and is no longer the case, or how you want the law to become. No, you are solving a problem, so you need to apply the law as currently enforced. And for that matter, it's only those authorities which are relevant in terms of being enforced, which we are supposed to be applied, and not just all the authorities in the particular area which we are dealing with. And some of them might have even been departed from, or some of them might have been overruled. Like that. So that is what we should keep in mind. So in terms of your selection of authorities to buttress your discussion of a problem question, you need to apply what we call the relevancy or materiality, like the most important authority as well, rather than just being doing some kind of a historical discussion. No, we don't do that in problem-based question. Okay, so have a very good night, and God willing, tomorrow at 9:30 we will be using the same link. So have a very